This matter is before the court on the plaintiff's motion for temporary custody, parenting time, exclusive use of the home, as well as other relief. Mr. Umloff, I think you've got probably the pleadings. I see that of things you've requested that some of them have simply, they've agreed to in their answer. They agreed to joint legal custody. They agreed that he would not consume alcohol during the parenting time, and he agreed to exclusive use. So if you wish to address the other matters, you can go ahead, Mr. Umloff.
Certainly, Your Honor. The parties separated in early September of last year due to the defendant's excessive drinking and verbal abuse of my client. Since the separation, defendant only had sporadic overnight parenting time with Catherine and Serena, the twin children. Most of that happening in the month of May. He had approximately 13 overnights with Catherine and 14 with Serena. Since the filing of our motion, I would note he had no parenting time in June until the 24th, which was after we filed our motion. The two children did go with him and stayed with him. They are still with him, although Catherine expressed that she wanted to leave, and due to the conditions that we've outlined in our motion in his home. And the defendant guilted Catherine into staying. My client has significant concerns regarding the condition of the home where the children are staying when they are with the defendant. The defendant drinks alcohol and smokes marijuana in excess, although I believe this is now a moot point as based on the response. Mr. O'Dowd is willing to agree to not drink alcohol in the presence of the minor children and not use any drugs, I believe, including marijuana. My client is also willing to agree to make that provision mutual, although she denies drinking in excess or using marijuana in the presence of the children. The children, when they are with their father, do not have their own bedrooms or beds and actually sleep in the den on air mattresses with their 12-year-old male cousin. They've reported that when they spend overnights with the defendant, they can hear him having sex with his new significant other, which makes them uncomfortable. He has multiple empty liquor bottles in his room. During the marriage, he drank regularly in excess of 2 pints of Jägermeister, and when under the influence became verbally abusive of Sarah in front of their children. After a recent overnight with their father, both children were very visibly upset. One of them cried for 40 minutes due to his behavior. In response to the allegations raised in the defendant's response, my client did not have an extramarital affair. She has started seeing someone since the parties separated. The children have met this person on exactly one occasion when he dropped by the children's grandmother's house on Thanksgiving. But they had limited interactions with him and have not seen him since. The defendant raised in his response the allegation that Serena has dropped out of marching band and claims that this is due to the party's divorce and by implication due to my client's conduct. This is simply not the case. Serena dropped out of marching band because some of the other children in marching band were bullying her and making her uncomfortable. The allegation that Catherine's grades have slipped is also inaccurate. Catherine, unfortunately, has had struggles academically dating back to 7th grade, well before this divorce. My client denies ever grabbing Catherine by her hair. And it is, as it relates to the issue of child support, the defendant left his job at managing several C-store locations in September. He provided no explanation to my client. The longest explanation and most thorough explanation that we got was in his response to this motion. At that time, he was making $22 per hour and receiving monthly bonuses of approximately $750 each month. He now works at McDonald's, making, at the time of filing our motion, we believed it was $17 an hour. He acknowledges now it was $17.50. We submit that he is voluntarily underemployed, and for that reason request that child support be calculated with him being imputed his previous wage of $22 per hour and his monthly bonus of $750 per month. As it relates to the parenting time for the children, we are asking that my client have primary physical custody and that the defendant have parenting time on a schedule of alternating weekends with standard alternating holidays. Thank you.
Okay, thank you. Ms. Thomas?
Your Honor, first of all, I'd like to acknowledge that on in my answer on number 7, letter L. I inadvertently switched the plaintiff and defendant in that one, so I apologize for that. As to counsel's comments, there's drastic disagreements. We are fine that they're willing to not have neither party use alcohol and or marijuana or any other any illegal drug, including marijuana, which of course is still illegal federally, during parenting time. I would ask that provision be maybe 8 hours prior to parenting time too, so that neither parent is starting parenting time on a situation where that they've been using which would be inappropriate. That this is a situation where the plaintiff has set forth to the court disparaging remarks, disparaging comments, things to obtain what she hopes would be primary physical custody. That is not the situation in this case. Up until recently, when the parties separated in September, both parents were involved with the children. Both parents love the girls. Both girls love their parents. Both parents have participated in activities and events. Both parents have guided and molded the girls into what they are today. However, things have changed. The girls are old enough to see the light that shines on each parent. They're old enough to have a voice in their immediate future situation. Although they are twins and they are well bonded with one another, each daughter also has a very close bond with her parents. It's not the same bond as with mom as with dad. It's different because they're all unique. It's a situation where they were all living together in the same home. Mom decides dad needs to go, dad goes. It took a minute because it was there wasn't a lot of notice on that. And so it took a minute for him to figure out what the plan was. He then worked it out with his mom so that there is plenty of space at his mom's house. That it's not true that the girls are sleeping on the floor or in the same room with their cousin. They've had their own beds for well over a month now. It's the whole thing about them hearing defendants having physical relations with somebody is not true. But even more and greater than that, that these girls are connected with mom, they're connected with dad. Both of those relationships with both daughters are based on love. It's not that I mean, they love each of their parents differently. Each of the parents love them differently. They treat their kids differently, as any parent that's an individual does. A careful review of plaintiff's request for physical custody shows no real specific reasons why she should be the custodial parent. In fact, frankly, there's not a whole lot even about the girls, other than a few generalized remarks. In those remarks, again, attempt to disparage the defendant. Plaintiff alleges that defendant drinks and uses marijuana. She fails to state that both parties drink, and it was commonplace for them to enjoy a joint together. So it's not as though that there is any clean hands here in that particular regard. Defendant understands that plaintiff's use of marijuana has increased significantly. That is obviously not from his own personal knowledge, but that's his understanding. While he has significantly decreased his use of alcohol, he understands that it does affect his children. He needs to not do that, and that's something he's been doing since the time of the separation, and quite frankly, just a little bit before that as well. Prior to when the parties first separated again, it was kind of a surprise for Mr. O'Dowd Jackson. So he needed a minute to be able to get it set up so that he could have his children. He was at a place where he could have the children and that would be, workable. And it's interesting too that during those early days that the plaintiff would contact the defendant and invite him to stay at the marital home with the girls so that she would in fact be free to continue her ongoing extramarital affair. Although Mr. Umloff states this morning that the girls have not seen him only on one occasion, it was on Thanksgiving, that we believe is a flat lie, in that there are multiple witnesses that can testify other than that. However, that in and of itself does not necessarily make a bad parent, as we both know. What does matter is putting the children first and making sure that the children are in a good home, a stable environment, which is, again, the reason that Mr. O'Dowd Jackson decided that it was important that he try to work something out with his mom so that that household was going to work, because it's a environment the girls are familiar with, they're comfortable with, everyone in that household loves them, and that need for them to have that at both houses was important to him. That's not necessarily what's going on at mom's house right now is our understanding. However, the backdrop is that there has been some issues, and although it was denied in this morning's argument, the defendant is absolutely willing to testify that he and others have seen plaintiff dragging Catherine to the ground by her hair. So that's, again, we're not saying she's a bad parent. We're wanting joint time with her, time with dad. But by the same token, there's not an angelic person wandering around here either in this particular case. Although Ms. O'Dowd Jackson alleges that she is willing and able to facilitate a close and continuing relationship with the defendant, it is first important to note that she would be unable to facilitate a close and continuing parent-child relationship if, in fact, a parent-child relationship, a close parent-child relationship already didn't exist. That's what they said, is that she's willing to facilitate a close and continuing parent-child relationship. So clearly there is one. And this is just argument for the sake of making argument about a reason to have sole physical custody, and that's inappropriate. In addition to that, she indicates she would not, do anything to not continue that. And yet she's asking, the parties have since, so when they first separated, it was a little bit until Mr. O'Dowd Jackson, it was a little bit more mom than dad, certainly. But for the last 2 months, it's been week on, week off, every week. And the only time it wasn't is that there was, in June, the parties agreed that mom was taking 2 weeks and then dad was taking 2 weeks, and it had to do with their individual respective plans for vacation time and whatever. So that was a change. But other than that, it has been week on, week off since May. The girls are doing well with that particular situation. In fact, as they've indicated, they would like to continue that situation. So we don't want to interfere with the relationship, and yet we're asking that right now, under the current situation, it would be on an annual basis, it would be 182.5 overnights. Yet Ms. O'Dowd Jackson is asking that Mr. O'Dowd Jackson go from that to 52 overnights, plus maybe a token overnight holiday. They didn't even ask for additional time for summer, like summer, even under the old standard quote unquote parenting time, included half of summer. We didn't even make an allegation or an interpretation of that by the plaintiff that was even appropriate. So clearly this is not about that. What this is really about in our view is this is about using hearsay, and they are hearsay because there's no way many of the allegations that she's made can possibly be known. It's using that and innuendo to obtain control. And the real crux of the matter comes to play in the allegations regarding child support. Plaintiff asked this court to impute income to defendant when she supported his decision to change jobs. And frankly, even if he hadn't have changed jobs, it's very clear based upon what was happening at the C-store. By the way, one single C-store, he never managed more than one. He managed different ones, only ever one at a time. They were looking to replace him. So even if he would have not left the C-store, they were still looking to replace him. He still wouldn't be working there. Rather than just sitting and dealing with that, he decided he would prefer to go and find a position that has upward mobility. The guarantee amount of potential, and it's truly a potential bonus in his past job, was based upon not only his personal job performance, it was also based upon how well the C-store did that particular month. So if the C-store did well, fine. He had an opportunity. If his work ethic and habits and whatever, if he did all of the things he was supposed to, then there was a potential of a bonus, but that wasn't in any way guaranteed. And it was based upon, the first step of that is based upon the C-store had to be making a profit that month, which is obviously not necessarily in the control of any of the individual employees. At this particular time, he is making $17.50 an hour. He's working 40 hours a week. He is on the I'm going to say the management path for McDonald's. They are at this point seemingly happy with him, and it's a situation where he's got potential for significant growth with the company, and based upon particular his past management experience. Yet at this point, you know, the plaintiff, she wants the kids, she wants the money, she wants it all, and it's not equitable. Frankly, it appears to Mr. O'Dowd that she's very consumed with her boyfriend and new lifestyle, and she is putting that before her daughters. Based upon all of that, we're requesting that a continuation of the status quo, with the parties enjoying week on, week off parenting time and sharing major decision-making of the girls under the provisions of joint legal custody. I understand that that is an agreement at this point. Mr. O'Dowd Jackson is also requesting child support be set pursuant to the Michigan Child Support Formula using actual party earnings, and that the parties alternate holidays pursuant to the Calhoun County Family Law Committee recommended holiday parenting schedule. He is further willing to stipulate to not drinking, as we now know, and apparently Mrs. O'Dowd Jackson is as well. And we would ask that that include both drinking, marijuana, and any illegal substances, and that it would also include 8 hours prior to their parenting, just so that at the beginning of their parenting time, both parents are alert, knowledgeable, and are in tune with their children. Mr. O'Dowd Jackson also requests that if this court is inclined to grant the request for exclusive use of the marital home, which he's fine with, that he would have an opportunity to go to the home, get his remaining personal things that not marital things. We're not asking that. And also that he have an opportunity to inventory the home as far as the marital items that are there, twofold. First of all, because we know that to make a property list fully and completely, he has to have access to do that, which eliminates the possibility of, at the end of a very long divorce, that we don't know what all the personal property is. Also, it's his understanding that already marital assets have begun to be dissipated, including an antique bed frame that was like his family's thing. So he would like, again, an opportunity to go there to get his remaining personal things, and also to be able to do an inventory. And that was at my request initially that was happening. Also, that she meaning plaintiff would be solely responsible for all of the, there's no mortgage, but all of the other expenses related to the marital home. And just so the court is aware, with the week on, week off parenting that's been happening, Mr. O'Dowd's week would start on July 7th, and they switch on Fridays at 6. They just had an up north and a little bit longer trip up north, and so they're doing a little bit of makeup right now. But anyway, this would be Mrs. O'Dowd's holiday would be July 4th, so alternating after that, and then Mr. O'Dowd's first full week of alternate parenting would be the week beginning on Friday, July 7th. Thank you.
Okay, thank you. Well, what the court's going to do in this matter is the parties have no dispute of joint legal custody. The court will grant to the parties joint legal custody. The court does believe that, again, in this matter, the status quo, other than just recently when they've switched some weeks, have been with the girls in the plaintiff's care. The court's going to continue that and grant to her physical custody. The court would grant to defendant standard parenting time, alternating weekends, midweek, as well as alternating holidays and alternating weeks in the summer. The court would, at this point, calculate support based upon his current income of $1,750. The court can adjust that when we have an evidentiary hearing or trial if the court believes that, again, imputation is necessary and appropriate at that time. The court would order that the parties would not consume alcohol, marijuana, or illegal drugs during the time that the children are in their care or for 8 hours before that. Court would also, in this matter, order that the girls, while in the defendant's care, have their own room, that they're not in a room with a 12-year-old male cousin. And court will grant to the plaintiff exclusive use of the home. The court will allow the plaintiff to box up, if you would, the defendant's personal items. He can pick those up when they do a parenting time exchange. And again, if there's some other items that are not included at that time, then you can exchange the list with the attorneys. And if you can't work it out, you can come back into court at that particular point. So that will be the order. Mr. Umloff, you can prepare that and submit it under 7-day notice of entry.
Your Honor,
Thank you, Your Honor.
can I ask a further question, please?
Yes,
Then it doesn't sound like the court is allowing Mr. O'Dowd Jackson.
I'm not, Miss Thomas. I didn't address that because I wasn't going to do that at this point.
Okay. Then my question is, can we include in the temporary order that there would be no further dissipation of marital assets, because that is what has apparently already happened?
Mr. Almoff, I don't assume you'll object to that.
I do not, Your Honor. We deny my client denies dissipating any marital assets, but certainly that can be put in the order.
That's fine, Mr. Almoff. Include that in your order.
Thank you, Your Honor.
Okay, thank you. Court will end this matter at 10:02 a.m. You're free to go.
Thank you, Your Honor.